starting, the today's concept which I'm going to discuss is concept of bails. Now the term bail has not been defined under the Criminal Procedure Code, but in the common terms it means giving liberty to an accused against some surety or assurance to the court that the accused would be available at the time of trial. This surety could be a personal bond or a bail bond. Bail is a mechanism basically to ensure that the accused is available before the court. Now the sections today which we would be dealing are sections 436 to section 439 of the Criminal Procedure Code. Let us first see when can bail be granted and who can grant bail. The Code of Criminal Procedure 1973 has defined the term bailable offence by stating that an offences which are shown bailable in the first schedule of the code or which are made bailable by any other law for time being in force. And the term non-bailable offence states that or means that offence that are not bailable in nature or other than the bailable offences. Now, the distinction between a bailable offence and a non-bailable offence is based on few factors. Those factors are firstly, gravity of the offence, danger of the accused absconding, tampering of his evidence, previous conduct, health, age, sex of the accused person, and the probability of him repeating the crime. Though the schedule for classification of offences of bailable or non-bailable is provided in CRPC, however, it is mostly seen that offences which are punishable with an imprisonment not less than 3 years are classified as non-bailable. So, example, offences which are punishable about 3 years. The two authorities who can grant bail are police and courts. Pausing here for a moment. Many of us feel that bails can be granted by courts. There is a special section of provisions in the Criminal Procedure Code which give power to police to grant bail. So first let us see what are the basic rules for denial of bail. Basic rules for denial or grant of bail. Now, bail in relation of bailable offences, section 436 of the Criminal Procedure says that it is the right of the accused to demand bail and he be granted, and it should be noted that it is mandatory to the court to grant bail while considering the various factors of the bail. Now, the basic criteria for denying or accepting bail in non-bailable offences has been discussed in the section 437 of the Criminal Procedure Code, and some criteria that again includes this nature of the offence, past criminal records, and probability of the guilt or probability of committing the offence. Innocent until proven guilty is the concept which is prevailing in the Indian laws. Hence, there is this concept of bail given like bail pending trial. Then comes section 438. Section 438 would be dealing with pre-arrest bail. There has to be a fine line of distinction between bail and a pre-arrest bail. A pre-arrest bail is one which is sought before going to the custody, and a normal bail is a bail which is sought after being sent to judicial custody. Now, the other factors which the honorable courts keep in mind while granting bail again are possibility of threatening the witnesses, possibility of tampering, absconding, and etc. These are going to be the underlining factors throughout when a judge has to decide an application for bail. Now, there was a very interesting question which rose before the High Court of Allahabad. Now, earlier in UP High Court, in Haji Muhammad Wasim versus State of UP, in the Allahabad High Court had questioned the police officer's validity of granting bail when the accused, in spite of being given bail by the police officer, failed to appear before the court. The magistrate was constrained to issue an warrant, and upon an application for a bail which was not allowed, the accused went to the High Court in 482 while deciding the question that is challenging the rejection of bail by the magistrate. The High Court has said that accused has to take fresh bail from the trial court because a condition was breached of him of not attending the court. So thus it can be concluded that when police give bail, the conditions which are given have to be mandatory followed, and if there is non-attendance before the court, then that bail is cancelled and there has to be fresh bail. Now let us see what is bail by police. Bail by police is like the power of the police officers to release an accused in bail who is in custody. There are two possibilities when police can give bail. One is without any arrest warrant, or secondly, when the issuance of warrants after the issuance of warrant, an arrest is made. The sections which we would be dealing when police officers have arrested to them are section 42, 43, 56, 59, 169, 170, 436, 437 and schedule 1 of column 5 of the criminal procedure code. Now, the power of the police to grant bail is controlled by the directions endorsed under section 71 of the criminal procedure code. However, section 81 of the criminal procedure code empowers a police officer to grant bail when an accused is arrested or produced before him or for commission of a bailable offense. Please note, bailable offense. Police can give bail only in bailable offenses even when no direction to this effect has been given in the warrant case. In case of a non-bailable offense, now when can police give bail in non-bailable offense? In case of a non-bailable offense, the endorsement on the warrant has to be strictly followed. If there is an endorsement of the warrant that upon the accused coming before the police, the magistrate has stated that there can be bail, then only the bail can be given. Also, if the endorsement of the warrant is not by a particular name, then the bail cannot be given. Now let us see what is section 42. Section 42 of the criminal procedure 1973 says that it can be invoked by the police officer when the offender refuses to give a name or address or has given name and address to the police officer which is false. If those particulars are within the knowledge of the police officer, neither the question of arrest nor the question of bail will arise. Pausing here, see, section 42 deals with police can invoke this section when they do not have address or name of the accused. But if the police officer has knowledge that this is the name and this is the address and yet he is harassing, then it is the right of the accused to get bail. As soon as the name and address has been ascertained by the police, that is, it has been physically verified or telephonically verified, email verified, the bail has to be granted and the police officer cannot detain him if he is willing to execute the necessary bond. If he is not willing to execute the necessary bond, then the police has to refer the concerned accused to the magistrate. The power to arrest and release can be exercised by any police officer, not necessarily by an officer in charge of the police station, because this section has been enacted to provide for a particular non-cognizable offense, does not put any restriction on the police officer to enlarge a person on bail after the correct name and residence have been arrested. Now, in Kajal Devi versus State of Assam, it was held that what is reasonable complaint or suspicion or what is a credible information depends upon the facts of each case. The presence of words reasonable and credible refer to the mind of police officer receiving the information, and such information must afford sufficient materials for the exercise of an independent judgment at the time of making arrest. So the two words are to be necessarily being referred, that is reasonable and credible. Now the police officer must believe that the information which is given to him is reasonable and credible. Credible means the credibility or the authenticity of the information is known by the police. If the police officer is not sure of the information received, then he can deny bail. Coming that Supreme Court in M. Bhaskaran versus State and Emperor versus Vimlabai Deshpande has held that when the legality of person arrested without a warrant is challenged in the court, it is the burden on the police officer to satisfy the court that he had reasonable grounds of suspicion. So basically, like earlier, the burden of proof is on the accused. Now the reasonable ground for suspicion has to be satisfied by the police officer. The police has to give plausible explanation stating that why he arrested the accused, what was the suspicion. Also, he has to say if there was any source of information which was received by him. Note here, the police officer does not have to disclose the source, that is the person from whom the information has come. He could just say, I received telephonic information from my secret informer about so and so thing. Now let us see what is section 43. The section 43 is a very unique section and I believe many of us have not heard it. This is when a private person can arrest an accused. Yes, when a private person can arrest an accused, he can arrest an accused only up to the time till production of the Supreme Court. It's to the production of the police station. In Abdul Habib versus State, it was held that The right of arrest under section 43 occurs to a private citizen on the base of his personal knowledge derived from the use of his own eyes in seeing a commission of a non-bailable and a cognizable offense being committed. For example, if I see murder has been committed by a person, I can place him under private arrest. After the arrest I have to take him to the nearest police station, and it is only then my role ceases. For example, this arrest could maximum be valid to 20 minutes or 25 minutes, like considering the distance up to the nearest police station. We do not have powers to arrest or detain a person for most of the time. The question of bail will then depend upon the police officer before whom the person has been brought. If the police officer believes that there is no sufficient ground to detain the person, or he has not committed the ground, then the police officer will release him. If the police officer believes that there is ground to detain him, if the police officer believes that there is ground to detain him, then as per section 41 of the Criminal Procedure Code, he would place the accused under arrest and the investigation would commence, and then it would be upon the accused, upon his disability of bail, to apply for bail after the remand, that is after the police custody is over and he is been remanded to judicial custody. Now a Supreme Court has held in Chota Nagpur Rural Police Act that a chokidar is not being a police officer and he is not entitled to receive the person who's arrested under this section. But where, if at all, a police chokidar has been given authorization by the police station of having a post of a police, then he can receive the person and detain him in custody as per section 59 of the Criminal Procedure Code. Now, the power conferred on a private person to arrest without warrant is limited only to those offences which are both non-bailable as well as cognizable also. Now, the next sections which come in consideration of bail are section 56, 57 and 59 of the Criminal Procedure Code. Section 56 mandates that a police officer affecting a person without warrant must take or send the offender arrested to the magistrate having jurisdiction of the police station. Section 56 says that there is an inbuilt provision authorizing a police officer to admit the arrested offender to bail, but the power of police officer is subject to the provisions contained here for bail only limited. Section 56 of the new code corresponds to section 60 of the old code. Now let's just see what is section 57. Section 57 provides that when a person is arrested, or he cannot be detained with more than 24 hours without producing before the magistrate. I'm reading out a quote from a particular book. The intention of the legislature is that accused person should be brought before a magistrate competent to try or commit with as late as possible. Section 57 is a pointer to the intendment to uphold the liberty and to restrict the minimum curtailment of the accused. It has been held in Sharif Bhai versus Abdul Razak. The failure of a police officer to produce an arrested person before the magistrate within 24 hours would result in wrongful detention. Because there is a tendency in the police officers to show the wrong time of arrest, to stretch the hours of the 24 hours. If it exceeds more than 24 hours before presenting to the accused, then that is wrongful decision. And this has again been held in Ashok Hussain Allah Deta versus Collector of Customs. It was held that this practice will not be permitted, and in DG and IG of Police versus Prem Sagar, it was clarified that this is a healthy provision that enables a magistrate to keep check on an investigation, and it is also important for the magistrate to try and enforce the requirement if investigation is not complied properly, and if at all a police officer fails, then it is the power of the magistrate to come up heavily upon the police, that is either issue show cause notice and upon hearing the officer take appropriate action. Now section 59. Section 59 of the code states that any person who has been arrested by the police shall be discharged on his own bond, bail, or under special order by a magistrate if the offense is punishable below 3 years. If the offense is punishable below 3 years, then only this power can be exercised. Now, section 169. Again, I'm reading a quote from the book which says that section 169 refers to the grant of bail not at the start but only on the making of an investigation under chapter 12 of the code. Till then, bail is not authorized. Understand, bail cannot be granted until and unless a particular person is arrested. The power to release a person on bail in custody vests in officer in charge of the police station or the police making the investigation. Either it could be the senior PI who's the head of the police station or the investigating officer. An officer in charge of the police station or an police officer making investigation cannot release a person on bail if he has appeared before the magistrate and the magistrate has referred him to custody. Only a person who appears before police officers, then only they can give bail. These are the provisional arrangements for bail which are made in case the offenses are less, and if there is investigation ordered by magistrate, then the police officer cannot release the particular accused on bail. If the police officer feels that there is reasonable suspicion in not granting bail, even if the offense is punishable below 3 years, then with justifiable grounds, he has to refer the matter to the magistrate, and the magistrate has to use his judicial mind and decide upon the bail. In Chaganati Satyanarayan versus State, it was held that the power of remand becomes exercisable in a magistrate only if the accused is presented before him. Hence, it is mandatory that the accused is presented before the magistrate between 24 hours of his arrest. Reason being, before magistrate, the magistrate cannot do anything. I am pausing here for a minute and I'm giving you an reference of this particular case which has just happened 2 or 3 backs. Can anyone tell me if they have heard about the Kerala encounter or the custodial death? At least one person who has read it could unmute and say if they have read it and give me some facts of the case. Any person who can give the facts of the Kerala encounters? Or the Tamil Nadu?
Yes, ma'am. It was the Tamil Nadu
Yes. Could you
custodial
please
death.
give us the fact so that I can explain here?
Yes, so there were two men, Jairaj and Phoenix, who were arrested by the police officers because they didn't close their shop before 8 p.m. considering the lockdown rules. So they were arrested by the police officials who took them to the police station and tortured them by beating up their knees and shoving things around their private places and ripped
Okay.
them, and which caused their death. And they during the postmortem reports it was stated that they died due to heart failure and fever, when the obvious reasons were due to their torture.
Okay. Now, since everybody knows the fact, what I would like to say is, in this matter, the High Court has taken so much of cognizance and they have ordered inquiry against the magistrate also. Pausing here, why inquiry against the magistrate also? Because it is categorically stated that when a person who's arrested is produced before the magistrate not only verbally but has to physically ascertain the condition of the accused, because nowadays it is seen there is the increase I'm sorry, there is an increase in police atrocities. In this case, the magistrate had seen the injuries because the number of injuries are more, yet he chose to send them to police custody. So the underlining point here is the magistrate not mechanically but also has to physically verify the condition of the accused. Mere asking, do you have any complaints of against the police will not suffice. Now let us go to section 170 of CRPC. Section 170 of CRPC says that under this section, a police officer is empowered to grant bail if the offense is bailable. it is submitted that a station officer is empowered to grant bail if the investigation has disclosed that the offense is bailable and it is immaterial what the initial accusation against him was. For example, initially an FIR was registered for an X offense, which was a non-bailable offense. But while investigation, if the police officer comes to know that the offense is a bailable offense, then forthwith he has to release the accused of for bail under bail as per section 170 of the CRPC. Now let's go to the main sections, that is section 437. We have seen in what conditions police can give bail. Now let us see what is section 437. The section 437 deals with power to give bail to a person of a non-bailable offense is, and this is conferred only to class 1 police officers, that is namely the in charge of the police station, that is the head of the police station. It could be a senior PI or any head, but it has to be head. Now subsection 1 of this section reads that when an officer in charge admits an accused to bail, it is mandatory for him to record the reasons for special reasons or whatever reasons in the case diary and preserve the bail bonds until they are discharged, either by the appearance of the accused in the court or by the order of a competent court. This is an exclusive power as per section 437(1), where a non-bailable offense is there. Now, for the purpose of bail in non-bailable offences, the legislator has classified them under 2 heads: those which are punishable with death or imprisonment or life, and second, which are not punishable to death or by death or life. The age, the sex, the sickness or infirmity of the accused can be considered by the police officer for the purpose of granting bail. The matters may be taken in view by the court only. Officer in charge of the police station may grant bail only when there are reasonable grounds for believing that the accused has committed a non-bailable offense, or when a non-bailable offense complaint is not of punishable with death or life imprisonment. So he has to believe the same, that an offense is committed, but it is not punishable by death or life. Now bail by police when arrest is made in pursuance of a warrant. Section 71 and 81 and 80 deal with this. Let us see. The relevant provisions would be 71 and 81. I'm reading out only a case law. In Lakshmi Narayan versus Emperor, it has been stated that it is a matter entirely in the discretion of the court issuing a warrant under this section to give a direction for release of the arrested person on bail or not. Even in bailable offense, a court may not give such direction when a person who is to be arrested is not arrested until the date on which he has to attend the court. The discretion regarding the taking bail lapses. For example, like I referred earlier, these are bails which are given on appearance before the police as per warrant. If a magistrate or a particular court, while issuing a warrant, states that this warrant would be only for production of the accused and the police officer has no power to grant him bail, then only the court can grant him bail and police officer cannot grant him bail. Now, section 80 and 81. This is said when the warrant is executed outside the district, which is issued by a police officer who is not the DSP or a commissioner of police, may release an arrested person according to the directions contained in the endorsement. Again, understand, whether the warrant is within the jurisdiction or without the jurisdiction, whatever is on the endorsement is mandatory, and for the police officer to follow. It is imperative for him to not dispose the directions written on the warrant, and he has to strictly comply with the directions. In Raghuvanshi Devichan Basin versus State of Maharashtra, an advocate came to be arrested though the warrant against him stood cancelled. However, the advocate failed to prove the documentary evidence of the same, that the warrant was cancelled. The Supreme Court rejected his prayer for enhancement of compensation, stating that merely because the warrant used the expression like a non-bailable and did not make the warrant bad in law. In the same case, the Supreme Court held that it is a duty of the High Courts to ensure proper maintenance of records by the subordinate courts. Thus, it should be noted that his prayer for enhancement of compensation was rejected because he did not have proper documents. Merely because the warrant mentions a non-bailable bird, it cannot be serious and bad in law, but there should be documentary evidence on record to provide for the same. Now we have dealt with police. Now let us see the concept of bails to lunatics. Section 330 of the CRPC says that bail cannot be claimed as a matter of rights for persons of unsound mind. Courts have been vested with great powers and wide discretion in the matter of grant or refusal of bail. A magistrate may release or may decline to release a person of unsound mind on bail even though he is charged of an offense of the most heinous type, and also may refuse in a bailable case. So it is the discretion of the magistrate if he is of the opinion that the bail should not be allowed. An accused of an unsound mind may be released on security irrespective of the offense which he is charged, not only on the finding by the court that the accused is of unsound mind, but also prior to such finding during the pendency of inquiry on his state of mind as per section 328 subclause 2. So based also same provisions are applying. The magistrate has to judiciously apply his mind. Only the thing is that they would be released by the court before the report. Normal cases, the report is not asked. In Hindustan Times versus Union of India, it was held that as regards undertrial prisons who have been charged under grave offences whose punishment is life imprisonment or death penalty, such persons shall be subjected to examinations periodically as provided in the subsections 1, 2, 3 of the section 39 of the Act, and the officer stated therein should send reports to the court whether the under trial prisoner is fit enough for the trial or to defend charges. This is like periodical medical examination. If upon a periodical medical examination it is found that the accused is not of proper condition, then it should be sent to the court, and without waiting for the accused to file in a bail application, the court on suo motu can consider this application for bail and decide aptly. But in this condition, only for under trial, the reports are going to be the evidence and imperative of the reports. There is nothing else. Now there is bail in process of contempt. When contempt proceedings are issued under section 346 of the Criminal Procedure Code, it is laid down how bail can be granted. I am again reading from the Bare Act here. When an offence as is described in section 175, 178, 179, 180 or 228 of the Indian Penal Code is committed in view of the presence of a criminal court, and that court, instead of proceeding under section 4, under section 345 of the Criminal Procedure Code, considers that the court considers that person accused of any such offences referred to above should be imprisonment. Otherwise, in default, a fine of the amount not exceeding 200 rupees should be imposed upon him. Then the court, after it has recorded the facts constituting the offences and the statement of the accused, may forward the magistrate having the jurisdiction trying the same. Pausing here, it is that when the above mentioned offences, that is offences under section 175, 178, 179, 180, 228 of the Indian Penal Code are found out to be committed by the accused, then the concerned court will record the statement of the accused and then refer the accused to the magistrate. Then the magistrate, on appearance of the accused and the referral from the court, shall take into consideration the facts and shall either forward the person in custody or as per the provisions of section 340, and then he cannot apply for the bail. The person who has complained against has not to apply for the bail. It is the discretion of the court forwarding the complaint earlier to ensure the attendance of the court accused by demanding security for appearance. For example, an offense of perjury is committed and it is come to the light of the High Court. The High Court, while referring the case to the magistrate, would state that while discussing about his bail or while giving his order, it would be mandatory for the magistrate to pass an order that this accused would attend the court or whatever place of attendance 2 times a week, 3 times a week, once a month, every first day of a month, every fortnight, every day, whatever, and that he cannot just because the accused who's produced before the magistrate has not applied for bail, it is available for contempt proceedings, he cannot be sent for custody. It has been held by Laki versus State of Maharashtra that merely because the accused has not applied for bail, he cannot be taken into custody. He can be taken into custody only if the security that is demanded from him is not there and there is no sufficient security. So understand, in a contempt proceeding, when the higher court refers the accused to the magistrate has to consider his application for bail even if he has not applied. Only he can send to the custody if he is not ready to furnish the proper security. Now, bail to first offenders as per section 360 of the Criminal Procedure Code. Of Subsection 1 of section 360 of the Criminal Procedure Code deals with the power of a court or a magistrate of the second class specially empowered by the state government on their behalf to release a convicted offender on his entering bond with or without sureties to appear and receive sentence when called upon during such period not exceeding 3 years as the magistrate may direct, and in meantime to keep the peace of the good behavior by executing a bond. The magistrate does as discretion either to punish the offender with imprisonment or release him on prohibition of good conduct. This section is basically inserted in the Criminal Procedure Code for reforming the criminals by treating them leniently. In Hari Singh versus Sukhbir Singh, the learned judge held that the court is to use this discretion in respect to prohibition judicially and have regard to the age, character, antecedents of the offender and the circumstances in which the offense was committed. The main aim of this section is to prevent youngsters from being committed to jail, where they may associate with hardened criminals who may lead them to further path of crime and further ruin their life due to bad influence. Such in Jamal Haq versus State of Tripura also it is held that this section has been inserted for reformative. Our constitution basically, or our constitution from which all our laws are derived, is based on the reformative theory. We do not believe in the theory of eye to eye, but we believe in reformation, and hence this section has been inducted wherein the magistrate or the second class magistrate feels that this accused should be released on bond as he's a first time offender, then the magistrate can release him on bond. This has to be differentiated with Probation of Offenders Act. Many confuse this section with the Probation of Offenders Act. The Probation of Offenders Act comes only in the picture when a court, that is the judge, either the magistrate, the judge of a sessions court, or any other judge pronounces before the accused that I have heard the evidence against you and I find it sufficient to convict you. The Probation of Offenders Act comes into picture only from the day of conviction to the quantum. After a accused has been convicted, till the quantum of sentence, he is at liberty to apply for the probation of offenders. Other than that, he can never apply for the probation of offenders. This thing. Now let us see what would be a pre-conviction or a pre-appeal bail as per section 389 of the Criminal Procedure Code. Now, a pre-conviction bail or a pre-appeal bail means that today, if a particular judge pronounces his sentence that so and so accused has been guilty of so and so offense, and I sentence him to so and so sentence. So and so sentence means the sentence has to be below 3 years. So if the sentence is up to if the sentence is below 3 years, then before the accused applies to the High Court in appeal challenging the order of the conviction, he can on the very same day of sentence apply before the concerned court for suspension of sentence and grant of bail till the filing of the appeal, that or till the appeal period. Appeal period means those days between which he has to file the appeal, that is 60 days. Under section 389, the concerned courts have the powers to grant bail till the appeal. Hence, it is like, for example, there are only two conditions which could be seen while granting this bail. That is, during the trial period, the accused was on bail and the accused is of a bailable nature. But nowadays, the courts have taken a considered view that if the conviction is up to 3 years or a little more, then that bail power can be exercised for a limited. This is called the limited bail, which is given to the accused only for the purpose of appeal, of filing an appeal. The moment an appeal is filed before the court, this bail ceases and immediately he will have to file a fresh bail application before the appellate court. It is only for the convicted person. In Khilari versus State of UP, it was held that irrespective whether the offense is bailable or non-bailable, the discretion of releasing the person on bail lies in the discretion of the appellate court, and this discretion has to be exercised judicially. Hence, the appellate court has stated that while giving the bail, the sessions court has to carefully ascertain as the final call would be of the appellate court. Again, in Manu Sharma versus NCT Delhi, it was held that the appellate court should, among other things, consider whether prima facie ground is disclosed for substantial doubt about the conviction and whether there is likelihood or understandable delay in disposal of the appeal. So, in Manu Sharma's case, it is seen that the court has to hold that there is a considerable doubt that the conviction which was given by the magistrate or the sessions court is not appropriate, and there is likelihood of the accused succeeding in the appeal, and the appeal is going to take time, and hence the bail needs to be continued. Considering these factors, the Supreme Court has held that the delay in hearing the appeal itself is not a sufficient ground to grant bail in Ravindra Singh versus Rajesh Ranjan. Now, bail while making reference under section 395 of the Criminal Procedure Code. When a magistrate makes a reference under the section 395 of the Criminal Procedure Code to the High Court for its own opinion on the validity or otherwise any other ordinance, regulation or any other section of the Act, he may in such case, pending the High Court's decision, either commit the accused to jail or release him on bail when he is called to appear upon. Generally, it is seen that he is released on bail. The magistrate has to exercise his jurisdiction and discretion in favor of the accused, considering the seriousness or the charges of the severity of the punishment that would be involved in the act, ordinance or regulation. So understand, the magistrate while before committal or while reference has to use the power under section 395 of the Criminal Procedure Code. Now, bail when revision under 397 is pending. Now, the Sessions Court or the High Court, while exercising its revisional jurisdiction, have a power to call upon records from the inferior courts for the purpose of satisfying them on the correctness, legality, or propriety of the finding, sentence, or whatever order is passed by the lower court. While the revisional court takes time to give the record or the record is prepared, till then the sentence can be suspended, and in case the accused is in confinement, bail can be granted. Thus, pending revision, bail is in the right of the accused. Now let's go to section 437 of the CRPC. Section 437 of the CRPC deals with a bailable offense. Grant of bail is a rule, whereas refusal in the context is an exception. A person accused of a bailable offense has a right to be released on bail. Bail in cases of bailable offenses is compulsory bail. It is a discretionary option to grant bail to a person accused of bailable offense. When a person who is suspected of committing a bailable offense is produced by a magistrate and he is prepared to give bail, the magistrate has to realize, has means it is mandatory to release him on bail without any option. Now, so basically, if he is ready only to execute the surety. Now, bail for offenses which are non-bailable as per section 437 of the CRPC. I'm reading out the section 437 of the CRPC. The provision of section 437 empowers two authorities to consider the question of bail. Namely, a court includes a high court and a court of session, and an officer in charge of the police station who was arrested or detained or detain without warrant a person accused or suspected of the commission of a non-bailable offense. Although this section deals with the power or the discretion of a court as well as a police officer in charge of a police station to grant bail in non-bailable cases, also had laid down certain restrictions on the power of a police officer to grant bail and certain rights of the accused to obtain bail when he is being tried by the magistrate. Section 437 of the code deals with the powers of the trial court and the magistrate to whom the offender is produced by the police officer or the accused, or wherever he surrenders or appears to grant or refuse bail to a person accused of or suspected of the commission of a non-bailable offense. So understand, the in case of a non-bailable offense, this power is discretionary and it has to be used prudently. It is not mandatory, whereas in cases of a bailable offense, it is mandatory to grant bail. Now let's see section 438, that is anticipatory bail. Anticipatory bail is something wherein an accused has apprehension that he would be put to arrest by the police officer. He applies to the court. He applies to the court for a bail. Just a second, there is some issue in that. Madam, I'm pausing here for a minute, huh?
Dharti, please mute yourself.
Okay, we were here on section 438. Section 438 deals with anticipatory bail. When an anticipatory bail is granted, when an accused has an apprehension that he would be put to arrest by the police, then he applies to the court for anticipatory bail. This is in common words also called as a pre-arrest bail. The belief that there are tangible grounds of him to be put to be arrested, then he goes to the court for anticipatory bail. Anticipatory bail, earlier it was a notion that anticipatory bail could be taken only from the sessions court and then to the high court, but this notion has been set to arrest. Now I am going to read the 41st Law Commission report. It says that it was stated that the need for this provision is that sometimes it is possible that it is stated that it was stated that the need for this provision is sometimes it is possible that influential persons with their power would try to fraudulently implicate any person in false cases to disgrace them or malign them by getting them detained in jail. This section works for the shield for a person who are likely to be detained. Subsection 2 of this states that as it may think fit, states that as it may think fit is the court will say that section 438 can be exercised only if the court believes that anticipatory bail can be granted to the accused. Now, till when the anticipatory bail will operate? Earlier, it was stated that till the starting of the trial, but after the judgment of Sitaram Mehta, it is stated that anticipatory bail will operate till the conclusion of the trial. Initially, like I said, it was said that only sessions court can first give the bail, and if it is rejected, then the accused has to apply to the high court. But the Honorable Supreme Court in Chandrasekhar Rao says V.Y. Kamala Kumari has clarified that a person can directly plead to the high court seeking anticipatory bail. Section 438 has a very wide scope. In case if the offense is non-bailable, it is immaterial whether the offense is cognizable or non-cognizable. The accused can exercise his powers of anticipatory bail. In Kuppa Naidu versus State, an anticipatory bail was granted to a person who was accused of committing an offense under the customs law. This shows the wide scope of the section. Anticipatory bail is applicable to many laws, and it can also be granted to a person whose punishment is up to life or death. Now I'm going to read down the guidelines which was read down by Guru Baksh Singh Sibhya. Like Guru Baksh Singh Sibhya of the state of Punjab, this is the landmark case which everyone has to know if he is referring to anticipatory bail. Now I'm going to read out certain guidelines which were given by the Guru Baksh Singh Sibhya. The difference between a normal bail and an anticipatory bail. The normal bail is granted when after the arrest, whereas an anticipatory bail is granted before the arrest. Anticipatory bail is granted in anticipation of the arrest. There is no restriction of granting anticipatory bail merely because an offense is punishable by life or death. The imminence of a likely arrest found on a reasonable belief can be shown to exist even when an FIR is not yet filed. Yes, pausing here. Merely because an FIR is filed, you are entitled for anticipatory bail is not there. There should be reasonable apprehension. Like for example, if police is calling you every now and then for inquiry, and you feel that after this inquiry they are going to put you under arrest after registering an offense, then you can apply to the court for anticipatory bail. In Babu Appai Joyalagiri versus State of Maharashtra, it was held that mere apprehension is sufficient for grant of anticipatory bail and approach of court. Babu Appa Joyalagiri versus State. I'm repeating the case law, and the earlier case was Guru Baksh Singh Sibhya versus State of Punjab, 1982 SCC 565. Now, the discretion of anticipatory bail has to be exercised. The next guideline. It is true that the discretion of grant of anticipatory bail is to be exercised with care and circumspection. However, it is not true to say that the power to grant anticipatory bail should be exercised only in exceptional cases. Court has to weigh all the circumstances in granting the bail. The status of the accused has not to be seen. Only the facts of the case have to be seen. The limitations that are imposed in 437 and 438 do not have any implications here. The High Court or the Sessions Court cannot leave the question behind with respect to anticipatory bail for the decision of the magistrate under section 437. The High Court has to use its own mind to check whether a case is valid for granting of such anticipatory bail. Considering the antecedents of the accused, and if it appears that it will take advantage of the anticipatory bail and flee from the justice, then the court should not pass order. In Mazur versus State of UP, it was held that even though judges have wide discretion to grant anticipatory bail, if they do not grant, they should mandatorily record the reason for doing so. The condition mentioned in subsection 2 are not exhaustive, and court may impose conditions. For example, I will give you a condition. As per the Maharashtra amendment to the section 438, it says that every accused while being granted anticipatory bail, the court has to give an order stating that this accused cannot leave the jurisdiction of the court. Considering the jurisdiction of the court, like for example, if a session court Mumbai is granting anticipatory bail, the jurisdiction of this court would be from VT to Mulund. So if he has to go anywhere, he has to take the permission of the court. So it is mandatory as per the Maharashtra amendment now that he cannot leave even the city without the permission of the court. So even if he has to travel from Mulund to Thane, he has to take the permission of the court. Not taking permission would amount to breach, and under such circumstances, the anticipatory bail lies to be cancelled. Now, with regards to the duration of effectiveness of the anticipatory bail, in H.C. Siva Prasad versus State of AP, it was held that the bail shall be effective till the conclusion of the trial. Like I have said, Siddharam Mhatre has confirmed this position, and like if at all, till the conclusion of the trial, if at all, as per 439(2), there is an application for cancellation of bail, the accused has a right to know on what grounds his bail was being cancelled. Now, let's see section 439, that is the regular bail, and we have understood anticipatory bail, that is a pre-arrest bail, when it can be cancelled, what are the parameters to cancel the bail. In section 439 empowers the High Court or the Sessions Court to grant bail. Now, when can you apply for the bail? Regular bail. You can apply for your regular bail only and only when you are in judicial custody. There are very rare cases where the accused can apply for bail in police custody. One of them being is, for example, the person who's arrested is not the accused. A is arrested thinking him as B, then he can immediately arrest for when they can immediately apply for bail. But this is a very rare condition because the police have to ascertain the identity of the accused before arresting him. In Naresh Kumar Yadav versus Ravindra Kumar, the court has held that a person is said to be in custody within the meaning of this section only when he in duress, either because he or she is held by investigation agency or other police allied authority, or is under control of the court and has been remanded to judicial order, or is in physical presence in the court. The discretion granted to High Court to grant bail is very wide and it remains unaltered. And it has been stated in Kalyan Chandra Sarkar versus Rajesh Khanna that Section 437 powers are an expansion which have given to the High Court. Now, Sanjay Chandra, that is Sanjay Chandra versus CBI. Again, this case is a very important case. Sanjay Chandra's case and Suresh Kalmadi's case are two very important cases which are considered to be important while granting bail. I am reading out the guidelines here. The accused is detained in custody not because of his guilt, but because there are sufficient probable grounds for the charge against him to make it proper that he should be tried, and because the detention is necessary to ensure presence during the trial. Like I earlier said, the bail is granted to ensure presence in trial. While granting bail, three main elements are necessary to be considered: is the nature of the evidence by which it is supported and the punishment to which the party is liable if it is being concerned, and whether he is going to be available at the time of the trial. Bail discretion on the basis of evidence about the criminal record of the defendant is also an exercise of relevance. A person is acquitted by the lower court for a graver offense. Applying for a bail at the High Court will have great chance of getting bail, as his chance of jumping the gauntlet of the justice is much lesser, as he already has the confidence of being acquitted once. So, example, if a person is already acquitted in the court, this says that there are much less chances of him being absconded. If the trial is taking longer period, it is in the interest of justice to grant bail to the accused, because it would not be proper to keep him in jail for indefinite period. The accused should not be denied bail merely because of the sentiments of a community is against bail. According to the law, accused is innocent until proven guilty. Here I would stop just because a particular community or a committee or a part of section of the society is going to be hurt after granting bail to the accused, he should not be denied bail. Court with reasonable conditions, or like reasonable conditions of him not entering the community or not contacting the person, can grant him bail. In A.K. Gopalan versus State of Maharashtra, it was held that the liberty of a citizen is undoubtedly important, but it has to keep in balance with the state of the community. A balance is required to maintain between the personal liberty of the accused as well as the investigational right of the police and the rights of the complainant. While granting bail, there is always going to be a conflict of personal liberty of the accused, which is a fundamental right of 20th, versus the society being exposed to the misadvantageous person alleged to have committed the crime. Liberty exists in proportion in the wholesome restraint. Somebody wanted Siddharam Maitre's this thing. Siddharam Maitre versus State of Maharashtra, it is 2012. Siddharam Maitre is used for anticipatory bail, and it is held that liberty is precious to an individual, so is the interest of society with respect of maintenance of peace and law and order. I am repeating Siddharam Maitre here because this judgment is used at the time of regular bail also and anticipatory bail also. So the Supreme Court has held that while granting bail or anticipatory bail, it has to be seen that while protecting a liberty of a person, it is also necessary to maintain peace, law and order, which is important. In Amarnath Tripathi, it was held that in Amarnath Tripathi versus State of UP, it was held that while granting bail, five parameters have to be considered: nature and the gravity of the offense, severity of the punishment if convicted, whether there is prima facie a ground or reasonable ground to believe that the accused has committed the offense, the danger of him absconding if released on bail, and likelihood of him repeating the offense. These 5 parameters have to be considered. Reasonable apprehension of witnesses being tampered. If the accused is granted bail, can be overruled by directing the accused to not entering the jurisdiction where the accused are staying. Now criteria for granting or refusing bail is absolutely a judicial discretion, and it has to be vested upon the courts. But the only thing which the courts have to consider while either granting or rejecting bail is that Article 21 of the Constitution, which consists of personal liberty, should be seen that personal liberty should not be hampered. Grant of bail is like gifting an accused his personal liberty, while grant of anticipatory bail is protecting from an arrest. But while protecting the personal liberty under Article 21, it is necessary for the court to keep in mind the peace, law and order, and this has been held in Shekhar Jadhav versus State of Maharashtra. Thus, it is stated that a person should not be deprived for bail. At the similar time, the society should also not suffer. So it is the responsibility of the court to maintain a balance. Now, in fact, the question of bail or jail is always seen while considering the case of bail, and hence it is only the judicial discretion of the court to decide this concept. Bail or jail was the concept which was decided in Sanjay Chandra, which was later on affirmed in Suresh Kalmadi's case. Now, what are the frequently asked questions? Frequently asked questions is, can a person be denied bail? As per section 436(2), if a person has violated conditions of the bail bond earlier, the court may refuse him bail on the subsequent occasion. He can also ask to pay for penalty for not appearing before the court. A court has powers to deny for bail. It is clear that the provisions related to bail in cases of a non-bailable offense gives a discretionary power to police and to the court. However, the power is not without any restraint. Section 437 disallows for the bail to be granted in the following condition. It appears that again, when there is reasonable apprehension that the offense can be repeated or it is punishable by a graver offense, and if he has been previously convicted for an offense of death or life. Now, many people have a question: can a bail once granted be cancelled, and what is the legal provision? There is no legal provision for cancellation of bail, but normally these applications are moved under section 439(2) of the Criminal Procedure Code. In Talibi's case, AR 1950, it was held that Honorable Court that the absence of such provision is not a lacuna, but as a recognized power of the High Court for cancellation of bail. So High Court has a power to cancel a bail of the accused upon an application under section 439(2). According to section 437(5), any court which has released a person on bail has power to direct the person be arrested up or take him into custody if the court feels there are reasonable grounds. Instead, Delhi administration versus Sanjay Gandhi, it was clearly stated that cancellation of bail necessary involves a review of a decision already made and can by and large be permitted only if reason of supervening circumstances are there. It would be no longer conducive to a fair trial to allow the accused to retain his freedom in the trial. For example, the accused is not appearing for the trial. He is going on hitting on the witnesses, or he's destroying the evidence, and it would not be possible for the trial to proceed, and it would release in the acquittal of the accused. Then his bail can be cancelled. The power to take back an accused in custody who has been enlarged on bail has to be exercised with care because it is a task for the court to determine whether by application of the test the probabilities of the prosecution in succeeding in proving the case and the respondent, that is the accused, tampering the witness, have to be weighed. So basically, merely because that the prosecution is going to succeed in conviction after putting the accused behind the bars cannot be the reason for cancellation of bail. In addition to that, there has to be tampering of the witness. So cancellation of bail needs solid grounds because it will amount to a review, and in general, criminal court's review is not possible. So it is generally said that bail granted by one court is challenged in the higher court for cancellation. Okay, now can bail be refused in bailable offences is a question which you normally ask. Section 436(2), that is of the and the chapter 38 of the Criminal Procedure Code has empowered the court for denial of bail in bailable cases if the accused failed to condition if the accused fails for the condition of bail bonds. Thus, basically, we have seen here that bail is a discretionary power, but the rule is bail and not jail. So it is the burden on the police or the courts granting bail to weigh the proper factors and then only grant bail. Madam, can we start the questionnaire now? Because I have covered all types of bails right now.
Yes,
Only
yes.
one minute. Only two things are left. One is the bail for juvenile. Section 12 of the Juvenile Act. Section 12 of the Juvenile Act now deals with bail regarding to juveniles. So basically, criminal procedure court's procedures won't apply there, and section 12 will apply for giving bail to a juvenile court, because this entire procedure will be taken in the juvenile court. Secondly, bail relating to women. It is mandatory that bail relating to women should be given, because bail of women has been replaced not by may, it is stated by shall. When a bail application is moved by a woman, the court may not, the court shall give bail. Then comes the medical bail. The medical bail would be given only after proper examination and reports, and the examination has to be preferably done by a government hospital, and only then the bail can be given. So this sums up your bail topic in short. I've tried to cover as much as possible.